Hi, everyone. Welcome. I'm Monica Hikimi. I'm on the faculty and one of the associate deans here at the law school. And I want to welcome you to the fourth in our Insights from the Quad series. This webinar is on criminal justice reform. It's the last webinar in the series for this calendar year. And before we dive in, I just want to cover a few housekeeping things. The first is just to let you know that since all of you are here today, and you have registered for the webinar, you'll get an email with a link to the final recording afterwards. And the link will also take you to the page where you can find all of the other webinars in this series. So if you haven't been with us for those webinars, I hope you'll check them out. The second is just to ask you to mark your calendars for our next webinar, which is on the Supreme Court in a Polarized America, featuring Professors Leah Littman, Julian Mortensen, and Richard Primus. And that webinar will be on Tuesday, January 21st at 5 p.m. Third, during these webinars, attendees will not be able to see each other, so you'll only be able to see the panelists. I want to let you know that we are preserving your privacy. And then fourth, just to let you know that we've had sporadic power outages in Ann Arbor today, so there is some chance that the webinar will shut down in the middle of our hour. And if that happens, we'll just get back online as soon as possible. I hope you'll bear with us. So with those housekeeping matters having have been resolved, let me just introduce our three panelists for today. The first is J.J. Prescott, who is the Henry King Ransom Professor of Law and the co-director of the Empirical Legal Studies Center and of the program in Law and Economics at the law school. Eve Brensky-Primus is the Yale Kamazar Collegiate Professor of Law here, and Margo Schlanger, the Wade H. and Doris M. McCree Collegiate Professor of Law and the co-director with JJ of the Empirical Legal Studies Center. As I said, our topic today is criminal justice reform. There's a lot to discuss, and we thought what we would do is we would tackle it in sort of four stages. So starting at the front end with policing, working our way through, second, criminal processing, third, incarceration, and fourth, record clearing. So Eve, welcome. And perhaps I can start with you and just ask you to talk a little bit about the legal regulation of police use of force, given that this has been so in the news and such a part of our political conversation in the past few months. And of course, before that. So how does the law regulate the extent to which and the ways in which the police use force? And what are some reforms that you might imagine to try to adjust the legal regulation in this area?
Okay, great. Well, thank you so much for having me on the panel. I'm looking forward to the conversation. I guess I'll start at the top with the Fourth Amendment to the United States Constitution, which protects people against unreasonable searches and seizures. So the United States Supreme Court has, through a trilogy of cases, the Garner, Graham, and Scott cases, set forth a reasonableness standard for how it regulates the police use of force. And that is exactly what it sounds like. It's this sort of all-inclusive totality of the circumstances standard that asks, what is the risk of harm to an officer or to the general public? What is the risk of harm that an officer would impose by using force? What is the severity of the crime at issue that an officer is investigating? And the court even considers what is the potential culpability of the suspect, and recognizes in its doctrine, it kind of also puts a thumb on the scale and the side of finding things to be reasonable, because it says police are involved in these rapidly unfolding circumstances where they have to make split-second decisions. And so there's a lot of deference baked into that standard toward police conduct. And then on top of it, if an individual believes that their Fourth Amendment rights have been violated because the officer used excessive force and they sue the police for that, there's all of these qualified immunity doctrines that come in to protect government actors who are working in the course of their employment. And so you'd have to show that not only did the police officer violate that sort of very amorphous reasonableness standard, but the way in which the officer did it was so clearly established that any officer would have recognized that what they did was illegal. So it's an incredibly difficult, very state or police friendly standard under the Fourth Amendment. Obviously, there are a lot of problems that we have seen with this, not the least of which is that the fact that it is so open-ended and that there's so much deference baked in both at the standard level and the qualified immunity level, it means there is not much constitutional regulation of the amount of force that police use. And it means that arbitrary, discriminatory, or harassing actions can go unchecked. And we've seen a lot of data to suggest that there are a lot of problems around the country with the amount of force that police officers are using in encounters with citizens, and particularly with people who are Black or brown. And we know there's a lot of implicit bias research that suggests that officers might deem individuals to be more dangerous based not on their actions, but potentially the color of their skin. In terms of potential solutions, there's lots of things that can be done. Some are being done or argued for at a meta level, and some at more of a subconstitutional level. So at a meta level, there are arguments to eliminate qualified immunity, either as a constitutional matter through the Supreme Court or at the level of statute, federal or state statute. That would do some good. I think you'd still have that sort of amorphous reasonableness standard in play underneath it unless you changed that. There are a lot of things that are also being argued at subconstitutional levels. So for example, technology could be used. Some people have argued that police officers could use things like terahertz scanners that could scan someone and see if they had a weapon, so that we wouldn't have these mistakes that there was a cell phone that they thought was a gun or something like that. There are state laws that will consider whether the police officer tried to de-escalate the situation or whether the police officer's conduct before the use of force was somehow an exacerbating factor, and what they should have done was leave as opposed to engage further. There's also movements to train and supervise police differently, both with respect to de-escalation strategies and with respect to implicit bias and how they interact with citizens. And then finally, there's the movement recently to defund the police and to basically transfer money that police agencies use to police communities to more social services that would obviate like the problems that give rise to these interactions in the first place. So it really exists at all different levels.
Great. And so, JJ, maybe I could come to you. So we just spoke with Eve about like high level force, the use of lethal force by police. But more recently, we've also been woken up to the fact that a lot of the woes in the criminal justice system begin outside the system and at a lower level, in particular, the burdens that are imposed on people, especially those who are in poverty or otherwise disenfranchised, by fines and fees. And I know you've been working on this area and the way in which technology might be used to reduce these access to justice barriers. So could you tell us a little bit more about the issues that arise in that context and some of what is going on to address it and what else we might do?
Great, thank you. And hello, everybody. It's really nice to be here. And I'm excited to see so many people listed in the participants. Wow. Okay, so fines and fees, I think, in the last 10 years have really come onto the radar, in part because, just the size, the magnitude of some of the criminal justice debt that people owe is just unbelievable. So in Ferguson, we found that, this debt led to huge numbers of warrants. And we now know that there are just a ton of outstanding warrants, not for having committed a crime, but just for failing to pay. And the consequences of having fines and fees as a form of punishment when people are unable to pay winds up snowballing. So first of all, there are additional fines and penalties if somebody can't make it to court, and eventually, they lose their license, which reduces their ability to earn, and often they wind up with a warrant for their arrest. And we know a bunch about what happens when somebody has a warrant for their arrest. First and foremost, they begin to avoid interactions with the government. They don't vote. Particularly important is that they don't call the police when they've been victimized. So there are all sorts of knock-on consequences for what might seem like a fairly minor part of the justice system, the use of fines and fees to regulate, essentially. So I think we know more and more about that over time. Reform has been slow to come. I mean, one of the big challenges is that fines and fees fund a lot of the justice system. And, for a few decades now, courts have been really reliant on it. In my view, one of the biggest challenges has been just figuring out how to get individual litigants or users of the courts in a place where they can communicate and resolve an outstanding dispute over a fine or a fee. The Supreme Court tells us that you can't jail somebody who is unable to pay. The problem is that from the Supreme Court, we don't really have any guidance on how to determine how somebody is, whether somebody is able to pay or not. And the default essentially is that if you don't deal with the issue, the court assumes that you're refusing to pay and proceeds in that way. And a lot of these solutions may be solvable through the use of technology. So one of the ways our system works is, in order to resolve an outstanding issue, you have to go to court. And going to court is scary and intimidating for a lot of people. It's also very costly for a lot of communities. I can take a day off work without any financial consequence, but most people who earn an hourly wage lose, maybe hundreds of dollars just to engage with the court about a ticket. And so technology actually opens up the possibility of people going to court for these more minor disputes on their phone or outside of normal court hours. And it really seems like that can make a huge difference down the road. So in addition to the use of technology to ease the access to courts, I think we need to spend a lot more time switching the default rules so that we don't start from the assumption that people can pay fines, especially in certain communities, and start with the assumption that, if the government wants them to pay, they're going to have to show that they're able to pay.
That makes perfect sense. And you and Eve have both raised issues, racial disparities in the criminal justice system and the effects on people who are impoverished or otherwise disenfranchised, that I think will keep coming up over the course of our conversation today. But before we move on from the sort of front end policing side of things, I want to ask you, Margo, what is DOJ's role in all of this? Because, of course, policing is done at the local level. And so to what extent does the federal government and the Department of Justice in particular get involved in the issues that Eve and JJ just mentioned?
Right. So like Eve and JJ, let me start by saying thanks for having me to this panel. It would be fun to see everybody's faces, but it's fun to see their names as well. Eve talked about qualified immunity and the obstacles to constitutional tort litigation. Qualified immunity applies to damage actions in particular. The other kind of lawsuit that can regulate governmental entities is injunctive cases, on the model, say, of Brown versus Board of Education. You need to desegregate, that kind of thing. So the thing about injunctive litigation with policing is that standing doctrines have stood in the way of injunctive litigation playing as major a role for policing as that kind of litigation has played in some other sorts of institutions. So the basic idea is, look, suppose chokeholds are very, very dangerous and being used way too much by, for example, the city of Los Angeles. Even somebody who's had a chokehold used against them does not have standing to enjoin it in the future, because in the future, the odds that he's going to be chokeholded again are pretty low. And so he can't seek an injunction. And class actions can solve some of that kind of issue, but not that much of it, because the members of the class aren't that likely to be chokeholded either. So in 1994, Congress stepped in and said, we feel like constitutional tort litigation is not doing enough to regulate the police. Damage actions are obstructed by qualified immunity. The injunctive actions are obstructed by standing doctrine. And so the Justice Department can step into that gap, and they can be the chief litigator for injunctive matters. And Congress passed a statute, which has since been recodified, which is at 34 USC 12601. So, although anybody who's looking it up, just in case you are interested, it used to be 42 USC 14141, and pretty much everybody who cites that old. It only got recodified like a couple months ago. So, what that statute does is it says that the Justice Department can step in and bring a lawsuit if there is a pattern or practice of misconduct that violates the Constitution. So, for example, that could be excessive force, it could be unjustified arrest, it could be race discrimination, it could be any number of other things, but those are the three kind of big ones. And the Justice Department, in some administrations, has used that authority with some vigor. I don't want to overstate it. I was involved in the team that brought the first of those cases There was a group of them. My own personal one, we filed 10 days late. So I filed the second one, my own self. But there was a team of us who did the first group of them. And they have become, and so they have been brought and pursued in some administrations and not in others. There have been essentially none in the current administration. But there were quite a few, I think 25 in the Obama administration. But 25 is only 25, right? That's nationwide, all of the police departments in the country, 25 lawsuits. But that's a big part of the DOJ intervention. They can sue and seek systemic reform and superintend that systemic reform by way of a monitoring set of provisions and a monitoring team that reports not to the plaintiffs, the Justice Department, not to the defendants, the police department, but to the court that has nominal superintending authority. Although the courts have tended to stay fairly far from involved in these cases. So that's one thing. And those lawsuits do two things. They regulate the police departments that are covered by them, and they also set up a model of what regulation could look like, so that many jurisdictions have taken the provisions of those decrees and voluntarily begun to follow them without a Justice Department involvement. And so they've had a sort of imitative effect that's been much broader than the couple hundred departments that have either been investigated or actually sued. Mm-hmm. So that's number one. In addition, the Justice Department has a lot of other authorities that turn out to bear on policing. So the Justice Department can threaten to withhold money under Title VI for race discrimination. It can bring lawsuits under the ADA or Section 504 of the Rehabilitation Act. It turns out, for example, that fully half of the people who are injured by police or who are seriously injured, no, I think that's wrong. It's half of the people who are killed by police, have mental illness. So getting at the disability piece of this puzzle is actually covering an enormous amount of the harm that is suffered by folks who have difficult, traumatic, violent encounters with the police. And so the Justice Department has an active ADA program and the like. Again, it varies by administration how active it is and what kinds of remedies the department seeks and how vigorous they are at enforcing it. But the Justice Department definitely has a place in this mix that fills in for some of the gaps. One other point that's not really responsive to your question, but I should just say it, is that in addition, recently, and by that I mean over the past 15 years, courts have become less reluctant to issue injunctions against police departments. Mm. And so where we used to see very few, there are now several hundred nationwide that don't involve the Justice Department. Its authority having been conferred in 1994, in the time since then, courts have allowed injunctive remedies in force cases, in stop and frisk cases, in a variety of cases in which the alleged unconstitutional conduct is common enough or focused enough on particular groups that courts have said that the standing problem is surmounted. And so there's been significant development of the law of injunctions in addition after DOJ acquired its authority.
Mm-hmm. I do want to move on, but before I do, Eve, I want to ask you one more question, which is, so it sounds like actually there's quite a bit of, from what Margo just said, there are quite a few options available to different organs of government to try to regulate the way in which policing is conducted. And so I guess the question for you that I just want to follow up on is, how effective are these regulatory mechanisms, and why is it that we continue to see the kinds of problems that we do, given all of this infrastructure that we have in place?
Yeah, it's a really good question. And I think part of this is it is very challenging to surmount a cultural problem. And we have a cultural problem in policing in this country. In part, if you just look at the historical ways in which officers have been hired and trained and what they do with respect to communities of color and poor communities in this country. It's very challenging. Like you can look at the training materials and see the amount of time that is spent on things like implicit bias or de-escalation is dwarfed by like the amount of training that is spent on report writing, right? That is spent on other aspects of policing. So you can have a lawsuit that you would file, like Professor Schlanger is talking about, where a monitor is put in place. And they can start to make some really good changes in a jurisdiction, but it's not permanent. And so what will often happen is you get, this is assuming you can surmount the standing requirements, right? Or you can go forward and get a judge to issue some kind of injunctive relief, which, yes, there's been a lot of inroads and there are more suits, but they're dwarfed by the number of police departments in the country, as Professor Schlanger was saying. So even if you get that injunctive relief, that monitor is in place for a period of time and then leaves. And if you don't sort of deal with the cultural problems that are at the root of how the department got to be having a pattern and practice of illegal conduct, it will revert right back to the way that the department originally operated. And so effectuating cultural change really does require thinking in policing about it in a different way and in interacting with the community that is being policed in a different way. And that's a different kind of lift from what sometimes is happening with reform around the country.
Great. Okay, let's move on to the second stage. So criminal processing, and JJ, maybe I could come to you and we could talk a little bit about what actually happens in court. And here we can maybe resurface some of the things we talked about earlier about some of the racial disparities and prejudices that enter the criminal justice system at the point of criminal processing. Because, of course, as many people know, people have long worried about these kinds of prejudices interfering with the roles of prosecutors and judges. So could you tell us a little bit about the research in this area and the barriers we face in addressing the disparities that arise over the course of criminal prosecution?
Sure. Yeah. I think we know a fair amount about the existence and maybe even the size of some of these disparities and where they enter. We know a lot less about the underlying mechanisms. And that's probably in part because there are many different mechanisms that work in different ways in different places. But the upshot is there are significant disparities by race in the criminal justice system, and they operate at all levels, and they tend to magnify over time. So, if there are disparities in who is arrested by the police, so for a given severity of crime, you're more likely to be arrested, then one of the consequences is a different set of people move on to the charging stage. And you might think that having multiple levels would have the effect of weeding out some of this bias, but if anything, it looks like the opposite happens. So we sort of have additional layering on of disparity at the prosecutorial charging and declination stage, and then also in the plea bargaining and ultimately potentially in the trial stage as well. So we know that that's happening. What we know a lot less about is exactly why it's happening. So various possibilities are, explicit bias and implicit bias. Those are, two that you often hear. One of those is, maybe easier to see. Implicit bias is really quite an innate form of human cognitive process. It's really difficult to resolve. And most of what we've tried to do in that space, especially when it comes to judges, for example, is tough because it requires training and practice and it's really resource intensive. The other possible source, and some of my work recently is focused on this, has been just our choice of procedures. So in the context of more minor types of infractions, for example, we still rely on a very traditional way of resolving disputes. So we have an adversarial process where people present evidence in person. It happens in a physical place, and people are expected to speak up for themselves. And it's really unclear whether that model works equally well for different groups. And if we were to think, for example, that people from different communities, maybe different nationalities, different cultures, approach that kind of system differently, it shouldn't be surprising that we might see different outcomes along the way. And in some recent work, I looked at the effect of moving certain types of low-level hearings online, where, for example, you wouldn't know the gender or the race or even the age of somebody. And the question was, are cases likely to come out the same? The answer is, it doesn't appear so. So there are some disparities in gender. It's hard to know what those are. Those could be differences that result from differences about the cases. It doesn't really change whatever those disparities are. But for race and age, in the context of civil infractions, it changes quite a bit. And so one question is why? One possibility is that by moving stuff into technology, we reduce the possibility of these face-to-face implicit biases that have been with us all the time. The other possibility is that different groups are better able to use technology and feel more comfortable, for example, writing out a response asynchronously to a charge rather than speaking up to somebody who sits on a podium that doesn't look like them. So I think there are sort of more questions over time, but what we know is that this is a real challenge, and there may be multiple sources for these kinds of disparities.
Mm-hmm, mm-hmm. And so, Eve, back to you. So tell us a little bit about then, JJ sort of describing this enormous problem, and it sort of like moves like a blob, the criminal justice system, and it's very hard maybe to get a grasp on exactly what the points of intervention might be in the course of, again, focusing still on court processing. But could you tell us a little bit maybe about like the individuals who have agency in the system? And I'm thinking in particular about like the progressive prosecution movement and the defense bar, and the extent to which these individuals who I know you train here at the law school, like you have a whole public defender program to train individuals to get into the criminal justice system and to do this work. So to what extent can individuals actually try to mitigate or reverse some of these problems?
Yeah, I think there's a lot that can be done by actors within the criminal justice system. I guess I'll start with the progressive prosecution movement, since you mentioned that first. As many of you know, there's been a huge push to elect progressive prosecutors around the country, from Larry Krasner in Philadelphia to Chesa Boudin in San Francisco, and more just elected in this month around the country. And this has become, for many people, like, the thing that they think is the fix to a lot of the problems of the criminal justice system. And I will be the first to say that hiring, civil rights lawyers or former defenders into these chief prosecutor roles can do a lot of good, because prosecutors do have a bunch of power within the system. So various ways that an elected prosecutor at the top of the prosecutorial agency can effectuate change include a lot of things like eliminating asking for cash bail for people who are charged with crimes. There's a ton of research that suggests that people who are poor, who can't afford to post bond before they are having a trial date, wind up feeling a different kind of pressure to plead guilty just to get out of being incarcerated. And so you have the system sort of crashing down on them in a way that it doesn't people who have resources. And these are predominantly, poor people of color who are being swept into and caged as part of the system pre-trial. So eliminating cash bail is a great way to both decrease, the amount of resources that are being spent on housing people, to increase racial justice in this country, right? And to stop people from pleading guilty due to pressure. There's also a lot of progressive prosecutors who have focused on alternatives to incarceration, whether it's diversion programs to deal with substance abuse or mental illness problems rather than incarceration, or whether it's not charging things that have mandatory minimum sentences that can jack up the amount of time that someone is in prison. So there's a lot that prosecutors can do, because they initiate these criminal charges and they have immense power in both the charging stage and in the plea bargaining stage. But I also will be the first to say, I think there are real limits also on the extent to which we should rely solely on progressive prosecution as sort of the solution to criminal justice problems, for two reasons, right? The first is, look, prosecutors don't have unlimited power in the system. There are a lot of other actors who will push back on their power, not the least of which include the legislatures who will enact additional crimes or can change the penalties in ways that can usurp what a progressive prosecutor wants to do. Judges who might not want to adhere to the sentence recommendations, even if they are progressive, or who won't allow for diversion. The programs themselves, that may or may not take people as part of a diversionary exercise. So there's lots of ways in which there's pressure. That's one thing, is that they don't have unlimited power. The other limit, I think, to the progressive prosecution movement is it is politically based. And so, all you need is what we often refer to as the Willie Horton effect. Like, you need one person who offends in a way, that reoffends in a way that, somehow indicts the entire system, and the body politic can turn on the progressive prosecutor and not reelect that person and go back to a law and order, crime control sort of mentality. So it's a political position, it's a political office, and it's subject to the rational or irrationality of the electorate. This also means that progressive prosecutors have a real difficult time getting elected in some of the parts of the country where they are most needed, because the population there doesn't have a progressive attitude toward prosecution. So I guess this segues to the other criminal justice actors in the system. There is one person in the criminal justice system who is tasked always with the responsibility and the privilege of being able to say, people have rights under the Constitution, under state laws, under state constitutions, and you can't trample on their rights on my watch. And that is the defender. So in this country, over 80% of people who are charged with crimes are poor and are represented by public defenders. And we need to take and fund that role seriously. Public defenders are the ones who will always stand up in court and call out racial injustice. They are the ones who will stand up in court and bring up police brutality when it has affected their clients. They are the ones who will stand up and raise arguments based on guilt and innocence, right? They will raise arguments based on improper police procedures, raise arguments based on constitutional rights being violated. And the biggest problem with public defense is that it isn't popular to fund indigent defense. And so what you see are just a lot of jurisdictions where public defenders are completely overwhelmed. So in the 1970s, the American Bar Association set forth these standards and said no public defender could effectively handle more than 150 felony cases in a year, or more than 400 misdemeanor cases in a year. And if you look at public defender agencies around the country, what you will see is public defenders in Baltimore handling over 260 felony cases, public defenders in Miami handling over 700 felony cases, public defenders in Chicago and Atlanta handling 2,000 misdemeanor cases. There was one study about public defenders in New Orleans handling 19,000 misdemeanor cases in a year. It's just impossible to do an effective job with so little funding. So one thing that people will argue for that I think is really important is pay parity, right? And resource parity between the prosecutorial and the defense functions. And if you had an adequately funded, robust defense, you would have individuals who could check systemic problems by police agencies, by prosecutorial agencies, by judicial departments, et cetera. So I think there's a lot that individual actors on both sides could do if they care about the racial inequalities in our system and they care about pursuing justice. We just have to give them the tools that will enable them to do it.
Mm-hmm, mm-hmm. Great. Okay, so I guess then we'll move on to, we've talked about policing, we've talked about criminal processing. Let's talk about our prison system. And Margo, this is an opportunity to come back to you. The fact that we have so many people in prison in this country is getting renewed attention from both the right and the left of our political spectrum. And so I'd like to just ask you a little bit about why we have this mass incarceration problem, what might be done about it, and what you think about these efforts to abolish it.
So I'm going to actually share what seems to me always to be the crucial picture on this topic, because sometimes people don't realize it. So hopefully I'm sharing now, yes?
Yes.
Okay. So this is American incarceration as a rate. These are population numbers, and this one is a rate over the last 50 years, since 1970. And so what you can see is that during my lifetime, not during some of our attendees' lifetimes, but during my lifetime, we had an incarcerative system that had well under 400,000 people in jail and prison. And then we went up and up and up and up and up until a peak in about 2008. And since then, there's been a decline, a slow decline. It's a decline in rate. So it's worked out to something closer to a plateau in population. As the population of the country has gone up, the population of our jails and prisons has stayed close to constant with a very small decline. As a rate, it's been a more significant decline. And I offer that picture to try to open up the imagination of people who think that like our criminal justice system has more or less always been the way it is now, because it has not. We're currently at about 2.2 million people in jail and prison, a third of that in jail, 2/3 of it in prison. And we used to be at well under 400,000. So the answer to why have we done that is a complicated mix of questions. It's a combination of the drug war, but it's not only the drug war, of increased politicization of criminal, of responses to criminal offending, where it is helpful to politicians to ratchet up the response to criminal offending, and an increased use of prison as not quite a first resort, but as a very salient thing to do for crime. Where it used to be that quite a large number of people were convicted of crimes and didn't go to prison. That proportion is much smaller now. And then finally, increased sentences. But of course, those things that I just said all beg the question, well, wait, why have we increased sentences? Why do we have increased political salience of crime and so on? And that's hard to answer. Race is definitely a piece of it, but the dynamics are actually not that dissimilar in states that are very racially homogenous. So you don't see a terribly different picture than the nationwide picture in Montana or Idaho or Wyoming. And those are states where the prison system is not, it's disproportionately incarcerating people of color, but boy, it's mostly a white system. So it's not only that race is going on, and it's not only that the war on drugs is what's going on. That's not the only piece of the story, although both of those are very important pieces of the story. I think some of it is just path dependent. I think that the Nixonian turn towards the politicization of crime has had a remarkable impact on the way that crime works. We see that in a huge variety of ways, where there used to be mass Christmas Day pardons. That was just a normal thing to happen. We don't see that anymore. So there's a large variety of reasons, and each one of them has added a bunch of stuff, a bunch of like 100,000 people here, 200,000 people there. Soon you're talking real numbers, right? So that's a piece of how we've gotten there. As far as abolition, some people who talk about abolition mean it, and they mean we really should be doing away with this. And some people are they're abolitionist. They're interested in decarceration in a way that is massive. And so they want the carceral turn to be a last resort rather than a first resort. And I think that the abolitionist talk is a mix between those two, but that a part of the idea is that the losses to communities, the losses to families, they accumulate as the number of people in prison go up. If you start taking, at this point, we've been in the world of mass incarceration for long enough that it's an enormous swath of poor and non-white communities, Black and brown communities in particular, where going to prison is one of the things that adult men share. Not all of them at all, but that many, many adult men share. And the disruption that's done to families, to access to good employment, to life chances, accumulates across that community, and in a way that is finally being given political account. And so I think the abolitionist idea is saying boy, you are not being imaginative enough. When you say, I don't know, how about instead of having the sentence for X crime be 20 years, we have it be 15 years. That's hard enough that as long as you're at it, how about like we decide whether we really need that person to go to prison at all? And if they do, how about a year? How about 2 years? How about we do something really that can get us back to the prison population, the prison and jail population of 1967, 68, 69, with the caveat that people don't want to go back to the crime rate of 1967, 68, 69. So they want smarter responses to crime, but they want like, we haven't always had a mass incarcerative system. Why can't we have that back?
Great. And so JJ, this is a good opportunity for me to come back to you, because I know you've also thought about how we might reduce the number of people that we're sending to prison. And Margo mentioned the point that, lots of people don't want to have a spiking crime rate. That is a political consideration that many people who work within the system have to think about as they think about how they might actually institute criminal justice reform. And so what do you think about, I sort of know what you think, but I think the world will be interested in what you think about the possibility of focusing on nonviolent crimes and on reducing the number of people who have committed drug offenses, to reducing that population in prison. Is that a sufficient corrective?
Right. So, I mean, that's been long, the focus of reformers who have suggested, listen, we can make a lot of difference by looking at people who are convicted of these essentially victimless crimes, who have more of a problem, medical problem than a crime problem. But I think increasingly people who work in this field know that that's not going to be sufficient. I mean, if you actually look, at least using our definition of what a violent crime is, most people in prison are actually there for what, the standard definition would call a violent crime. So, really a lot turns here on politics and also on the purposes of punishment. Why do we actually send people to prison, and how do those purposes interact with the people who have to make decisions? I mean, Eve earlier mentioned, Willie Horton. Like, one of the challenges here is just the political risk of making changes. It's really easy. And I've seen it a million times where people suggest, listen, well, let's go a little bit harsher. How can it make things worse? It can only make things better. And the opposite move is really difficult to do. But, if we're focused on public safety, which is sort of where I start from, although there are lots of other reasons potentially to put people in prison, some, at least plausibly okay, and others terrible as a way of essentially controlling populations and so on. But if we're thinking about public safety, it seems increasingly that the evidence suggests that we're way over incarcerating. I mean, even if we think about violent crime. So some recent work I did looked at murderers, right? On the assumption that, people who commit murder or homicide are the paradigmatic violent, criminal offender. And people will worry about those people in particular being released at all, even though, of course, in most of the world, they are released, after a relatively short number of years. And so the question is, what's likely to happen? And we have data, increasingly we have data where you can look at these questions. And the answer is, people who are arrested and convicted of a homicide, if we're thinking about how likely they are to commit a homicide, if they're released 15 years later, especially if they're older, let's say over 50, the answer is basically there's no real risk difference between them and most other people. I mean, there is a slight risk difference, but it's really small. And the idea that you would just keep these people in prison for the rest of their lives, at least from let's think about how we should use these resources to make this, our society safer, it seems like a really bad investment. So increasingly, it seems like that we could release a lot of people, even people who've been convicted of violent crimes, after 10 or 15 years without dramatically affecting the crime rates we see. And indeed, if we did that, we could think about actually making much more headway on crime by channeling those resources in other ways. We spend a lot of money on incarcerating people, and those people can't contribute to society. They obviously obviously affects neighborhoods, communities, and families, and so on. If we instead used a lot of that money, instead of to destroy so much, instead to heal and into medical care and mental health treatment, the likely consequences would be sort of win-win on all sides. But it's just a really politically risky move, even when the evidence suggests that it would pay off in huge ways.
So Eve, so I want to follow up on this with you and to ask about some of the alternatives to incarceration, and particularly restorative justice as an option that we might pursue instead of pursuing incarceration in a number of these cases. So could you tell us a little bit about that as a possibility?
Yeah, absolutely. One thing that we know about prison is that it often is criminogenic, right? Like people who are sent to prison wind up becoming more hardened and committing more criminal offenses by virtue of their time in prison. And so one thing that has been proposed and used in a number of different places around the country to deal with as an alternative to incarceration is this concept of restorative justice or transformative justice. And this is actually, I think, a really exciting development in potential criminal justice reform for a couple of reasons. The concept of restorative justice is this idea that rather than just throw someone in a cage and forget about them for an extended period of time, what we can do is we can get someone in a discussion circle, someone who has wronged someone and someone who has been the victim of a wrong, and the people in their communities can be a part of that circle as well. And there's a conversation where someone who has been harmed says, this is the effect that the crime you committed had on me. And they talk about ways that a defendant can take steps to experience and understand better what that person has done to another member of the community. So for example, like you could see from a carjacking case, if someone was carjacked and they said, like, I am scared to get into a car and I ride buses only now as a result of what you did to me. And I'm going to ask you for a week before we come back to this discussion circle to never get in a car, to only ride a bus for a week and come back so that you can understand one of the effects of the crime that you committed and what it does to my life. And people come back, and there have been wonderful studies that people really do start to understand the consequences of what they did with respect to another human being and the community around them, and that people do not repeat offend, having gone through restorative justice processes. And there's a healing, not just for the defendant to understand what they've done that is wrong, but also for the victim, because in our system, so often there's this sense that like just punishing someone or putting them in prison is the way to like make a victim whole. And it actually doesn't make a victim whole in a lot of circumstances. That this reckoning, this conversation, this understanding, because the victim then can also understand the defendant's background and what maybe led the defendant to the position in that person's life where they did what they did. And so people have done this in a lot of different areas with violent crime. They've done it with sexual assault crime. They've done it with a lot of the crimes that are not just drug crimes, that are the ones that involve victims. And for those who are interested in learning more about this, there's Danielle Sered wrote a wonderful book about this called Until We Reckon, where she documents how restorative justice has worked and the studies about how effective it's been. So there are ways to deal with the problem of criminal acts without incarceration that can actually be, better for society.
Great. And we're getting toward the end of our time, but I do want to spend just a little bit of time on the fourth stage that I mentioned earlier, which is sort of the back end, record clearing process. And I think this is a part of the criminal justice system that people who haven't themselves interacted with the justice system don't think much about. But JJ, I know you've done a lot of work on it. And the question is, the issue is, let me say, that there are lots of collateral effects, even if someone is just arrested, in that they get a mark on their record that is very, very difficult to clear, and that affects their life in their life outside of the criminal justice system in all sorts of ways. And so recently, states have been focusing a lot on record clearing reform. And so can you tell us what has been going on in this area and what your own research has shown.
Yes. So yeah, one of the things, the internet's great for many things, including this get together here, but it's not so great when you have a criminal record. And increasingly, one of the things we know is that if you've made a mistake, you had something that you thought you left behind years and years and years ago, it can really haunt you, totally transform your life in ways that not only are hard for you, but are actually terrible for society, because your kids don't get the resources they need. It's harder for you to find stable housing. It's difficult for you to contribute to society. And so increasingly, because this information is more easy for employers and landlords and so on to obtain, a move to clean the slate, to allow people to have a fresh start, under certain conditions where it seems like they deserve it. And so for a long time, laws have been in place that have allowed this in a few places, but the process has always been really difficult. So in order to do it for example, in Michigan until just recently, it's petition based, but in order to succeed with that process, you had to get your fingers, you have to get fingerprints, you have to go to court. The list of things you have to navigate is really long, and a full page, tiny print. And the consequence is that very few people actually did it. Even those people who, legislatures decide, ought to have a clean slate. In fact, in Michigan, some of my work, along with Sonia Starr, showed that the uptake rate was only 6.5%. And, that's pretty surprising if we, given how important this ought to be to moving on. So really the recent moves in Pennsylvania and Utah and California and Michigan have been to move towards automatic expungement. And with the internet and the technology that comes with it, also comes the possibility of us identifying people whose records are worthy of being cleaned without them actually going through a burdensome process. And so Michigan, in fact, just not even a month ago, finally enacted, I think, first in country legislation on this, expanding the kinds of crimes that can be expunged from what was in place before, and adding a new automatic expungement process. And there are lots of reasons to think this is going to be great. First of all, it doesn't seem that people who are receiving expungements, at least in the past in Michigan, pose any greater threat in terms of likely committing a crime. Recidivism rates are really quite low. In fact, people who've received the thousands and thousands of people who've received set-asides, which are what Michigan calls expungements, in Michigan over the last 20 years, are actually less likely to commit a crime than the average adult in Michigan. Mm. So that could be for two reasons. It could be that if you go through the waiting period, which was 5 years, you're older, you've gone through the waiting period, you're just not that likely to commit a crime if you've done, if you're in that situation. So it could be that, which should also make us feel comfortable about moving on, allowing these people to have a fresh start. But on top of that, there are lots of reasons to think that it will actually change their ability to provide for their families and so on. And all of those things we know are reducing risk factors for returning to crime. So the hope is, again, another win-win situation. If we clean records, we have the opportunity to both reduce crime and give a bunch of people, and criminal records are rife in our society. I mean, depending on what measure you use, anywhere from 15 to 40% of Americans have some sort of criminal record. And it's been a real problem. And so as all these people who have been in prison are coming back, we need to start thinking about reentry. And this is one of those considerations.
Absolutely. Okay, well, we are just about out of time. So I want to say to the three of you, thank you so much. I learned a lot from you, as I always do. So thank you for being here. And I will clap to all of you on behalf of the group, and to those of you viewing at home. Thank you so much for joining for sharing your evening with us. It's really delightful to have you here. We hope that you stay healthy and safe over the next few months, and that you have a good Thanksgiving and a nice holiday season, and you return to see us on January 21st for the webinar on the Supreme Court in a Polarized America. So please take care, please stay healthy, and thank you again to our panelists. It was really wonderful chatting with all of you this evening.
Go blue.